Who's covered under this new law?
Go ahead.
So this new law covers all police officers, firefighters, first responders, also includes nurses and people who work in care facilities, so nursing homes. And I think the key here is that the legislatures were very intentional about making sure that the people on the front lines who are helping people and may become exposed or have a greater likelihood of being exposed to this illness, that they're covered.
I think an interesting aspect that we don't really know the answer yet is how far or how expansive this list is going to be. There is some language within the statute that talks about other assistive employees. So the question is, what about that janitor who's working at the hospital? Is that individual covered? I would argue yes, that individual would be covered. So there's any number of individuals that you would not necessarily think or believe would be covered that I believe eventually would be. For example, let's say that you are an administrative assistant at a police department. In my opinion, if unfortunately you were to develop COVID-19, the end result is that we believe that you may very well be entitled to the same protections as your fellow colleagues.
I think another important thing to think about is that even if you're not under the presumption and you don't get the benefit of the presumption, you can still bring a claim for work comp benefits if you contract COVID-19. So this presumption provides an extra benefit, and it shifts the burden of proof from the injured worker to the employer and insurer. But even if you don't have the benefit of the presumption, it does not bar you from bringing a claim for this type of injury.
And it's probably a good point to talk about what does a rebuttable presumption mean. What it does not mean is that you are automatically entitled to that benefit. So even if you're a police officer, law enforcement officer, etc., if you develop COVID-19, you are not automatically qualified. That's a misnomer that everyone may be lulled into a false sense of security. There's a presumption that it is, but your city, your county, the state might try to argue that in fact it was not causally related to your work activities. So the presumption is rebuttable, which means that the burden has now shifted to the employer, that the employer must demonstrate that the work activities were not a direct cause of the contraction of the COVID-19. So you run into interesting issues, like for example, we have a client already, unfortunately, who has developed COVID-19, but his wife is a nurse and also developed COVID-19. So both of them would qualify under the statutory presumption, but their respective employers could argue that it was not caused by their work activities, but rather was due to their exposure to the other. So now the burden would be on their employers to prove that, and I believe that it would be a very difficult thing to prove, but it is an issue that will come up, particularly if unfortunately someone's condition becomes a severe condition where we're dealing with a lot of monetary loss, whether it be medical expenses, whether it be wage loss, or even unfortunately long-term disability or even death.